The next matter to come before us this morning is Nationstar Mortgage LLC versus Charles Young. Are all of the representatives for that case here?
Yes,
and are you ready to proceed?
Yes.
Thank you. Come on up. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, if you let me know when you get started, I am keeping the clock this morning and can keep you apprised of the passage of time. The court's read the briefs and we're ready to proceed when you are.
Good morning, Your Honor. Excuse me. May it please the court, my name is John Cope. I'm with Thompson High and I filed an appearance in the case. I'd like to reserve 3 minutes for rebuttal. This is an appeal from a summary judgment decision from the Summit County Trial Court. So this court reviews it with a de novo standard of review. The trial court dismissed my client's quiet title action, stating that it had no right to try and challenge a competing lien holder's lien on the property that my client owns because things have been already decided in a prior bankruptcy case. There are two problems with the trial court's decision. First, the res judicata defense wasn't pled by the Youngs in this case. They had two opportunities to plead, but they didn't plead the defense. The second problem...
They raised estoppel, right?
Correct, Your Honor. They asserted estoppel and also waiver. But estoppel and waiver are treated as different defenses under the civil rules. And in fact, one of the cases they cited in their brief states that you don't preserve res judicata by pleading waiver and estoppel. So the case law is pretty clear. If you don't assert those claims, you waive them. There's an Ohio Supreme Court case called Jim's Steakhouse, which is controlling. In Jim's Steakhouse, the city had actually initially pled res judicata in their first answer. Then the complaint got amended, but then in the answer to the amended complaint, the city forgot to put res judicata back in. The city tried to raise it before trial, and the court rejected it. They tried to raise it at trial, the court rejected it. They tried to raise it after trial, on JMOB, the court rejected it. It went up to the Court of Appeals, and the Court of Appeals in that case said no, they could assert res judicata. It went up to the Ohio Supreme Court, and the Ohio Supreme Court said, no, I'm sorry, we're not going to reach the merits of the res judicata issue because even though you put it in your first answer, you didn't put it in your answer to the amended complaint, you waived it, city, I'm sorry, you're out of luck, you can't assert it now.
Nonetheless, many Ohio courts of appeals have said that it's okay to raise it for the first time on summary judgment.
There are some older cases, some pre-civil rules cases, that said that res judicata could be raised in a summary judgment motion.
I mean, the 2012 case.
Well, those all rely back on these older cases, and I think when you really dig into the case law and really pick it apart, you start to see what happened. Sometimes an appellate decision can grow life of its own when the circumstances have changed. But
I understand that. You cite a case maybe not the most appropriate way, and then somebody else picks up on it, and 5 years later you've got 100 cases that say the wrong thing. And
it becomes very hard to be the person standing in court. Thankfully, I don't have 500 cases against me in this particular proceeding. The appellees have cited this court to a case called Freeman from the Ohio Supreme Court, which does not state that you can raise judicata if you've already waived it from your pleadings. That case, there was a motion to dismiss asserting res judicata, which got converted to a summary judgment motion before pleadings were ever filed. So the party in that case never had their opportunity to plead the defense. And the court said in some dicta in that case that if you have a particular set of circumstances where you're pre-pleadings and you file a motion to dismiss that is properly converted to a 56 motion, then the court can entertain that res judicata argument. In that particular Supreme Court case, though, the court decided it wasn't properly converted, so the court never had to reach the issue. Now, the Freeman court in that dicta was citing some dicta from a case called Johnson, and Johnson actually supports my client's position because the Court of Appeals in Johnson assumed, without deciding, that you could raise res judicata for the first time in a summary judgment motion after your pleadings were closed. If you read the decision carefully, the court starts out and says, hey, by the way, the civil rules changed the landscape here, and we think you actually had to plead this. But if you, assuming it was even raised in the motion, and assuming that you could do that still for the first time in a post-civil rules environment, we are going to look at the merits, and we decided that the merits in that case didn't support res judicata, so there was a reversal. So the court in that Johnson case assumed without deciding that you could assert res judicata for the first time on appeal. Now, as Your Honor pointed out, there have been other later appellate decisions that like to cite the Johnson case and that sometimes cite the dicta from the Freeman case, kind of shorthand version without walking through all the steps and the timing of how a case is pled out and asserted in a case. But we respectfully disagree with the decisions in some of those cases for the reasons I just stated. So the first problem is that the defense was raised altogether. The second problem with the trial court's decision is that on the merits, res judicata doesn't bar my client from challenging this lien. My client has a right under the statutes to assert a quiet title action to challenge any lien on its property. My client is the title holder. They filed an action to assert a lien. To challenge the lien of the Youngs. The Youngs came back and said, well, there was a bankruptcy that our daughter had, and in that bankruptcy, because nobody said nothing bad about our lien, and there was a confirmation of our daughter's plan, somehow that means no one could ever challenge our mortgage lien ever again. The problem with it is that the bankruptcy court never adjudicated the validity or extent of their lien. There's nothing in the bankruptcy plan that was confirmed that talks about their mortgage or talks about how much of it is a secured claim or how much of it's unpaid. The Youngs aren't mentioned anywhere in the plan. Same thing with the confirmation order. There's nothing in the confirmation order itself that adjudicated anything about their mortgage or their lien or the value of their secured claim or whether they had a valid secured claim to begin with. In fact, when the court looks at the record and reads the confirmation order, not only did it not affirmatively adjudicate anything, it expressly stated that it wasn't adjudicating whether they had a valid secured claim. There's a provision in the confirmation order that expressly states that if someone wants to adjudicate the extent and value of someone's lien that was scheduled, then you actually have to file a separate motion, or under the bankruptcy rules, under 7001, you can file an adversary proceeding. You do that process, and then we'll have an adjudication about that thing. But the confirmation of the plan, which is only confirming treatments of classifications of claims and is not adjudicating all of the claims. I mean, that's for the claim process later on down the road. That's for an adversary proceeding under 7001 down the road, if it ever comes up. But the confirmation just confirms the treatment of classes of claims. It doesn't say that claims are valid at all. Now, in the trial court, the Youngs have pointed out in their reply brief, well, we got this bankruptcy rule 3003, and it says that the schedules that the debtor files in a bankruptcy are prima facie evidence that we have a valid secured claim. So since nobody stood up and said anything at confirmation, that bankruptcy rule applies somehow, and means that our claim's been adjudicated and no one can fight with us about our claim ever again. Well, we didn't have a chance to file a cert reply. The trial court relied on that bankruptcy rule when it decided that res judicata applied. The problem is that bankruptcy rule has zero application in a Chapter 13 case. The very first sentence of the rule says this rule applies in Chapter 9 municipality cases and in Chapter 11 cases. The rule has no application. And I submit to you that if the federal system decided they needed an affirmative rule in Rule 3003 to make the schedules prima facie evidence, that must mean that the schedules don't establish and prove anything to begin with. I mean, they created a rule for Chapter 9 and Chapter 11 cases to make it prima facie evidence. So in all the other types of chapter cases, it necessarily must be true that those schedules have no binding precedence or authority on the claims and liens in those other cases. Why else would you have a Rule 3003 for Chapter 9 and Chapter 11 if all schedules in all bankruptcy cases established and proved the claims? The other thing about Bankruptcy Rule 3003 is it only says it's prima facie evidence. So at best, it would just be setting up some evidence of a claim. It doesn't mean that it actually adjudicates the claim. Now, my opposing counsel has stated in their merit brief in this court that Bankruptcy Rule 3003 is a red herring. Well, that may be true, but it's a red herring that they put into the case in the trial court. It's a red herring that the trial court relied upon erroneously to decide that res judicata applied to bar my client's claims. So I agree that it's a red herring, but it's something that was caused and put into this case because of how the Youngs approached the matter. So there was never anything actually adjudicated in the bankruptcy court in respect to their mortgage or its value. The Youngs never even put an appearance in the case, in the bankruptcy case. They didn't file a proof of claim in the bankruptcy case. I mean, literally nothing happened to adjudicate or decide whether their lien was valid. And my client has very legitimate concerns about the validity of their mortgage claim. We did get to do some discovery in the trial court under oath and depositions. The Youngs admitted that they didn't even know that their daughter had given them a mortgage until a year or two after she recorded it. If you look at the facts as we laid them out in our brief, the timing on this was Dad and his daughter Stephanie decided to build one of their many spec homes that they build. He provided a bunch of money. He says $50,000, but they could only prove $26,000 of it with checks. And those things were used to pay subcontractors and the like. So he provides this money in like 2003. Then she borrows the money and mortgages the house. She falls on hard times, has trouble. Just a couple months before she files bankruptcy, and literally like a week before my client files the foreclosure action, she handwrites out a form mortgage for her parents. She's clearly planning. She knows what she's doing. So she writes out a mortgage and records it without delivering it to her parents, without telling her parents about it, and files it. I'm assuming in the hope that it might not show up and they will get something out after she files bankruptcy. Yes, my client's prior foreclosure counsel made a mistake by not naming the Youngs in the foreclosure action, but that mistake only made the property subject to their lien. It didn't adjudicate and deem that their lien was valid. My client respectfully requests that this court reverse the trial court here. They waived their defense. Even if they could assert their defense, it doesn't apply because the bankruptcy court never adjudicated anything. My client respectfully requests that the court allow it its day in court on the merits of this case instead of proceeding on a baseless procedural argument. Thank you.
Good morning, Your Honor. Robert Stefanson from the law firm of Ice Miller on behalf of the appellees, Charles and Gertrude Young. Your Honors, Gertrude Young is sitting in the back of the room in the red blouse with her daughter Stephanie. For a while, as I was preparing for the oral argument in this matter, I was struggling with just how to approach what I consider to believe the real issues that are involved in this case. And I sat back and I started to think to myself that, we tell everybody that you have to accept the consequence of your actions and the way that you perform and the way that you behave. In this case, there's been no doubt that this quiet title action was brought by Nationstar, who acquired its rights from Aurora Loan Services as part of the foreclosure that we've all been talking about and is mentioned in the briefs. Prior counsel, and the counsel that wrote the briefs, the counsel that drafted the complaint in this matter, has admitted that as part of that foreclosure, they hired a title company to prepare a preliminary judicial report. That title company did its job. It prepared a preliminary judicial report, but it made a mistake. It missed my client's mortgage. They've admitted that, and in discovery, we asked them, did you bring a claim against the title company because they missed the mortgage in the search for the preliminary judicial title? The answer was no. We haven't brought a claim against the title company. So The title company makes a mistake, but Aurora Loan Services and now this client who acquired its rights to Aurora says, we're not worried about that, it's no foul. As part of the record in this case, it's been clear that as part of Stephanie Young and Mark Dene, her husband's Chapter 13, Aurora Loan Services knew of my client's mortgage in the property. In a motion for relief from stay that is referenced in the papers, Aurora listed my clients as having a lien against the property. They're required to do that under the bankruptcy rules when they move for relief from stay. After they acquired relief from stay and admitted knowing about my client's claim, they went back to federal district court where they had filed their foreclosure, and they did not add my clients even at that point. They then foreclosed the property, depriving my client of its due process rights in that foreclosure case, and then transferred the bid to Nationstar, who now says, hey, in this case, we're not really bound by anything that happened. We're not bound by anything that Aurora Loan Services did. And we believe that the claim, which is still a mortgage against the property, is subject to challenge because we were somehow not at fault. They've argued on a couple of occasions that somehow, equitably, my client's lien should disappear. It doesn't. That's not the way foreclosure works. But what's interesting to me is, rather than blame the title company and say to the title company, we want you to cover your mistake, rather than admit, as he did here at the podium, that the lawyers made a mistake twice. Once not bringing the claim against the Youngs, and second, after they knew, not including them in the foreclosure. They somehow have chosen to bring a quiet title action, have my clients spend thousands of dollars in attorney's fees and costs in doing discovery, all because of their mistakes. And their rationale is, okay, we believe that at some point the Youngs did not provide consideration for the mortgage. And counsel's right. They did depositions of my client. My client produced checks where they provided their daughter with money in order to finish the construction of this home on Top Flight Drive. And other funds as they built other houses. They provided receipts, and they had not canceled checks that totaled $57,000, but both Mr. and Mrs. Young testified in those depositions that they had provided more money than that to their daughter. Yet somehow we're here. We're still continuing. And we're continuing because they still don't recognize their mistake and want to try to find a way to get my client's lien knocked out without admitting their mistake. That's not good public policy. That's not what should be sanctioned by the courts. As respect to the facts, as counsel stated.
Can you found your summary judgment motion?
Yes.
I know you argued res judicata.
Yes.
What else did you argue?
We argued res judicata. We argued waiver with respect to the state court action. And that was for purposes of our motion for summary judgment. We argued both theories in the summary judgment motion, arguing res judicata under the bankruptcy code, under 1327, and then common law waiver and estoppel because of the actions that were taken in the state court. Those are the two different arguments we presented to the trial court. Getting back to counsel's statement with respect to the facts, Stephanie Young is a home builder, or she was a home builder. She owned Honeybee Builders. They built spec homes, they repaired homes, they flipped houses. And from time to time, she would borrow money from her parents in order to do that. In this case, Miss Young and her husband knew that they were struggling financially. And they decided to prefer their mom and dad with respect to the money that was advanced and gave their mom and dad a mortgage in Top Flight Drive. There's nothing wrong with that. They then filed bankruptcy. In the bankruptcy, in the schedules, they listed their Mr. and Mrs. Young, my clients, as creditors, as secured creditors in the bankruptcy case. The mortgage that was filled out and filed simply says that their debt will be repaid when the house is sold. So at the time of the Chapter 13 case, the house was not yet sold, but the debtors, Miss Young and Mr. Dene, listed them as a secured creditor in the case. Trustee didn't challenge the lien. Nobody else challenged the lien. And as the Chapter 13 process works, if you don't have a mortgage arrearage, you're not really included in the plan for purposes of receiving payments under the plan. And in fact, the plan says that if you hold a mortgage which is not subject to arrearage, that you're going to be paid according to the terms of your mortgage. So in this case, my clients believed that they were going to get paid when the house got sold. In the Chapter 13 case, again, nobody challenged the mortgage. I want to get back to Your Honor's question to counsel about the effect of res judicata under 1327. As we stated in our papers, 1327 doesn't use the term res judicata in its statute. It doesn't say that. Courts have interpreted the provisions, the bar in 1327, to have what they call res judicata effect. And we cited a couple of cases in our papers, and I have a third, that talks about the fact that it's not quite res judicata, it's more like a claim preclusion. So with respect to the issues of res judicata and the litigation and the actual, hey, I've got to litigate the validity of the mortgage in every issue under the sun for it to be res judicata, just isn't true. So, Your Honor, when I say in my papers that I've pled waiver and estoppel, we didn't plead res judicata as a defense, but it's not truly the state res judicata defense. We actually argued that in our papers before the trial court. I want to get to the issue of the summary judgment, res judicata and the waiver of res judicata in the answer. We cited in our papers a number of appellate court cases. And one of the appellate court cases that we cited is an unreported case. It's International EPDM Rubber Roofing Systems, and it's actually attached to our brief as required by the local rules. That court, which it was a court of appeals in the state of Ohio, in Lucas County, went through the analysis of Jim's Steakhouse and the Supreme Court cases dealing with the waiver of the defense of res judicata if it's not included in the answer, if it's raised for the first time in summary judgment. While Jim's Steakhouse says it's not proper, really in Jim's Steakhouse, if we're going to talk about distinguishing cases, that was also a case where the Ohio Supreme Court said, well, you don't really raise res judicata in a motion to dismiss, and they converted it to a motion for summary judgment and found that there were no grounds to support the defense. We also cite in our papers a couple of Court of Appeals cases, Thayer versus Diver, which is out of the 6th District, again, Lucas County, in 2009, as Your Honor talked about, where the court actually says, we recognize that the defense of res judicata may be raised for the first time in a motion for summary judgment. We also cited in our papers the Court of Appeals case of Lalix, which also we believe stands for the same proposition. One of the arguments that was made in the papers below but was not addressed by the court was, assuming we didn't plead it properly in the answer, and assume that we can't raise it for the first time on summary judgment, we did argue to the court that under Civil Rule 15, we're entitled to have a defense, or raise a defense, which conforms to the evidence should we ever get to trial. This defense and the issues that we raised with respect to Stephanie Young's and Mark Stenay's bankruptcy case really wasn't a surprise to this party. They asked us for discovery that listed anything that we were going to use at trial for the purposes of raising defenses. And we provided a copy of Ms. Young's plans. We provided a copy of Ms. Young's schedules and statement of financial affairs, and all the documents which were included, and addressed it with counsel a number of times. I understand that they're going to take the technical argument that it wasn't pled, just like they want to make the technical argument that at some point we're going to be able to knock out this mortgage despite the fact that our mistakes allow the Young's mortgage to be elevated to first position. The fact of the matter is, the court could have decided, should we ever get to trial, that she could admit this evidence even if we don't move to amend our complaint, or amend our answer.
Well, the thing is though, I understand your argument, but on the other hand, when you say about technical stuff, it could be something to the benefit of one of your clients as well, that the whole point of discovery and so forth is that you know what the issues are, and if you raise something for the first time on summary judgment, usually the point of that is you've completed your discovery. So, you know, it is kind of like a surprise or an ambush type thing. Some courts are not going to allow you to engage in additional discovery.
Oh.
So it is for the purpose of protecting everyone.
Mm-hmm. And Your Honor, I guess my point was that we did the discovery, the written discovery, before we did my client's depositions. And in that written discovery, they asked us for documents relating to our defenses. And we provided them copies of Ms. Young's bankruptcy pleadings.
But you never said res judicata at that point.
That's true. But my clients weren't asked about it in deposition either.
But that's not my point. The point is, isn't the whole point, divorce yourself from this case.
I understand.
Isn't the whole point of that is so that you know what the issues are when you're conducting discovery?
I understand your point, Your Honor. And I guess my point back to that, or my argument back to that is, yeah, we could have amended our answer. We could have asked the court under the civil rules to amend our answer. But we did the written discovery before they did the depositions of my client. And they didn't ask my clients anything about those documents. They had them in their possession. They knew we were going to raise them. Why else would they be produced in discoveries being relevant documents? But they didn't ask about it at deposition. They had every right to do that. That's my point. The written discovery came before the oral depositions and came well before we filed our summary judgment motions as scheduled by the court.
In this particular case, moving back from the pleading in the state court case to the Chapter 13 bankruptcy, what in the confirmation order is res judicata against presenting this claim in the future in the state court?
My argument, Your Honor, is that as Ms. Young and Mr. Dene recognized, my client's mortgage as a secured claim in the case, the trustee recognized it as well by the way, by the fact that he has to put in a report of the claimants that he has paid in the Chapter 13 case and listed my clients as a secured creditor. My client's lien passes through as long as it's not been challenged or the Chapter 13 plan gets confirmed. If you read 1327, my clients don't have to file an objection to the plan. My clients don't have to receive a payment from the plan in order for it to be binding. The statute says, 1327 says, that the provisions of a confirmed plan are binding on the debtor and each creditor.
As it relates to the plan.
As it relates to the confirmation of the plan. My client's a creditor. They were a creditor. They had a right to try to value the property in that case and knock out my client's lien, strip the client's lien down. So did the trustee.
But the trustee could decide not to do so.
That's right. Just like a trustee in a Chapter 13 or 11 or 7 can choose not to bring a preference claim. In this case, that would be the trustee's claim, and a creditor could ask probably for derivative standing to bring it, but the trustee chose not to do that. Nobody can go back now and say, well, that claim was preferential, even if it was done a day before the bankruptcy filing. Nobody has the right to do that because that claim should have been brought as part of the 13 case, and it wasn't.
And that almost seems like it's a waiver argument.
Well, because it's the provisions of the plan in the cases under 1327. I understand your point, Your Honor. But that's because, again, we're talking about not in the statute it's saying res judicata, but the court saying it's got res judicata effect. Like, it's claim preclusion. That's what the cases say.
And I unfortunately need to inform you, you've reached the end of your allotted 15-minute time. Thank you.
Thank you, Your Honor.
Counsel, you have 2 minutes and 45 seconds remaining.
Thank you, Your Honor. First thing, opposing counsel emphasized, well, nobody challenged us in the bankruptcy court. Well, my client doesn't, or my client's predecessor, Aurora, doesn't get the benefit of filing an anti-proof of claim in the bankruptcy court. The decision of a trustee not to challenge something may very well be because I'm not going to spend money to challenge that. That sails through the bankruptcy, and if it's ever going to be challenged, it'll be challenged some other date and time.
Isn't that a big risk?
For the trustee?
You're in a situation where you're in that right now.
Well, my client wasn't involved in the bankruptcy case at all. My client received the bid post-bankruptcy from Aurora Loan Services. The fact of the matter is, and this comes back to the heart of res judicata, the mortgage was never put in issue in the bankruptcy case. When counsel first stood up, he spoke for a while about, living with the consequences of your decisions and things of that nature. It's slightly ironic that their failure to plead is not something that they want to live up to. Yet they're telling my client that they need to accept their consequences of not naming the Youngs in the prior action. Again, my client didn't control the foreclosure action and was a separate party from that. But there's a big difference. My clients accepted its consequences of the Youngs not being named in the foreclosure action.
How have you accepted it?
They have spent money on a quiet title action.
Well, that's not accepting it, is it? You're just
Well,
trying to attack it another way.
No, you have to understand what the consequence of the failure to name them was. The consequence of the failure to name a party in a foreclosure action is that that lien doesn't get extinguished. The consequence is not that that lien is a valid and adjudicated a valid and enforceable lien. The consequence is that nobody passed on it. So it lives to see another day. Well, my client is now spending money having to deal with that consequence. It's trying to fight off that lien now on the other day.
Well, and their response to that is you have a remedy, and the remedy, that's why you have title insurance.
Well, we do have title insurance, and claims were asserted for title insurance, but that doesn't control the outcome of the res judicata question, which is what's before this court. Yes, if we lose, and we can't, and foreclosure counsel, if this doesn't get reversed and foreclosure counsel doesn't win the quiet title claim, there's a lot of money that's been spent. Someone's going to pay for it, and someone's going to look to a title insurer for that money. But that doesn't mean that we lay down our swords and say, okay, someone else might pay us. In fact, if we do lay down our swords, that title insurer is going to say, I'm sorry, I'm not paying you. You didn't see your day out in court. And that gets us back to the merits of the case, Your Honor, which is, again, it was waived.
I need to also let you know that you've reached the end of your allotted time. Thank you both, counsel, for your presentations this morning. The court will take the matter under advisement and issue a written decision which will be on to both sides, as well as posted on our website and the Ohio Supreme Court website. Thank you, gentlemen.
Thank you.